illicit acts special land use permit. Before we dive in, Mr. Cross and I had a discussion about what might be perceived as a potential conflict. So I'm going to give him the opportunity to speak briefly to that. Oh, wait, before that, we should do a roll. I'm sorry. I always get out of order. Madam Clerk.
Mr. Myers is here. Mr. Martinez, I did not see him in the list. Member Rivera is here. Member Bronga is here. Member Johnson is here. Member Constant is here. Member Zalatel is here. Member Cross is here. I do not see Member Volland here. Correct me if I'm wrong. Member Brawley is here. I do not see Member Salt here. And I do not see Member Perez-Verdia here.
All right, so good enough. And now, Ms. Cross, are you there? I don't mean to put you on the spot, but it's just better to briefly talk about it.
Yeah, I'm here.
Okay, so I don't know if you heard, but I mentioned that we had a discussion about the potential of a conflict, and I just want to let you put on the record the nature of the relationship.
Oh, I share a wall. I rent one of Quantum Laundry's locations at 409 West Fireweed Lane. Business shares a wall with the petitioner. We don't,
Yeah, you don't own the building. Yeah,
I don't own the building. I don't have any fine off the agents. In fact, my previous conversations with this individual pretty much have to do with are limited to parking and making sure we all get along for the traffic our businesses generate. It's been pretty much just limited to that.
Perfect. So it's definitely the ruling of the chair. There was no personal or financial interest here. I just wanted to make sure it was clear on the record. So before we get started into the merits of the issue relating to the special land use permit, or the conversation, maybe not issue is the right way to say it, we had hoped to have a discussion now here about quasi judicial proceedings, because this is a quasi judicial proceeding. And so apologies to the petitioner, but you are at the perfect time and place for us to have a little bit of briefing on how we're supposed to conduct our business in these types of settings. So I think we had a discussion with Mr. Gates to talk about this, or Mr. Hurt.
Hello.
Hello. Mr. Gates, are you there?
Yes, I'm here. So my apologies. So I was requested to talk about the quasi-judicial or administrative process for the assembly during a rules committee meeting, and when it was canceled, I go, okay, I didn't actually prepare any materials or anything specific for that. So sort of on the spot and on the fly. What we mean by quasi-judicial is where there's a decision being made that affects as individual persons or business being person, their rights and the rights given under their code or the law. And so it's different than when you're making policy or legislation, right? Which is more of a general nature and affects everyone that operates under that law or nature. So here it's for example, today, Frosted Acts wants a special land use permit. And so we have outlined in our code all the requirements and criteria that one must meet to get a special land use permit for alcohol. And in addition to the state's separate alcohol license process. So for anybody serving alcohol here, you've got the liquor license from the state, and we have a process where we see our ability as a local government to protest the liquor license. But we also have a requirement for a special land use permit. Sometimes they're called conditional use permits generally. So the decision, though, is not a policy one. It's whether the applicant has met all these criteria that's in the code, and whether they have a history, whether they're in good standing with the municipality. And so in the packet that you see provided is the staff analysis from planning that sort of outlines their response to this criteria, whether they've met it or not. Now, sometimes there's other information because there's a public hearing involved that the assembly receives that maybe indicate, well, they actually don't meet this criteria, or they're, I don't have the criteria in front of me. My apologies. But when at the conclusion of a public hearing, given all the information you have from the planning analysis and the testimony or other evidence that's been there, and this is the important part, anything that you're considering must be part of the record for this person, because if there's a denial, there's an ability to appeal the denial of a right that they've been given under Title 21 in this instance. You need to have good reasons. You can't be unreasonable. You hear that phrase often, if the decision is unreasonable, arbitrary, or capricious. And, arbitrary is, well, we're going to deny this license from some reason. I don't like the operator, something unrelated to all the criteria that they've met or that they need to meet to get this permit. Or if it's unreasonable because you're basing on something that's well, I don't know if I can expound very accurately on all of that without having a nice outlined presentation for you, but I think you get the idea. You need to have good reasons for the denial of special land use permit or other, I guess, decision where you might be granting someone a right. And so, Mr. Constant, I think that was pretty brief and kind of just scratching the surface. But is there more I could add here?
I guess
Or I invite Mr. Hurds.
we'll probably come back to this again then when we have another opportunity with a more fulsome briefing. This actually should be an item in a file you have somewhere that you can generally just pull out and say, these are the facts and this is what it means, because this will come up every few years as new members come on. But Ms. Zalatil does have a question.
I have a question, but I have a couple of things I think are really important before we go into the particular special land use permit to keep in mind. So the special land use permit, if you were feeling like it wasn't an appropriate thing, right? Like you wanted to deny the special land use permit, it requires findings, specific findings of fact in the record, which means that you have to do a lot of work just as a member. I mean, this is the practical part of it, to draft up what those findings are and have them prepared in advance so that members can consider them and be prepared to debate them when the item comes back before us. In particular, there's kind of a format for that if that's where you're headed. And two, I think it's really important to think about those standards that Dean was talking about, arbitrary and capricious. So you have to really ground yourself in what's before us, what's officially before us in the record. And that means not something you heard, not something you saw. It's truly what's in the documentation. And that's such a different concept than anything else we do. And I think it's one of the hardest things to kind of get your head around. It is literally kind of what's right before us. So it also should then, as we have these work sessions or we have a special land use permit coming up before us, really drive what it is what your questions are in terms of what you want to see in the record if something is missing that you think is important, and how to request to find that out so it's officially before you. So I just wanted to add those kind of pieces for the practical perspective of ways to think about how to process some of this information.
Yep, thanks. So I want to add, it's not just documents. Yeah, it's not just documents, but it could be comments from members of the public that are relating to the record. Really, it's the record. And the record is the process convened where everybody has noticed this conversation is going to happen at this time and place. All the parties are allowed to be present and they're allowed to respond or make comment. And so that's the part I think that's super important. It's the documents we have plus the public comments that we receive. The whole record is what we have, but not in the case of in particular special land use permits. I went over and looked and found, because those kind of things I think are not allowed. That's what falls into what's called ex parte communication, meaning outside of the record. And so we're having this conversation because whenever we get to those last items on the agenda, the 15s, and sometimes earlier, they're they are quasi judicial in nature and are subject to a different set of rules. And so there is a training, Anna tells us in the chat, from 2019. So we may be able to review that and pull from that in the future. But I think gets to the gist. Mr. Gates.
Yes, thank you. I was going to add that part about the ex parte communications, and that's very important. So in the 15s of the agenda, when you see it, you don't want to go calling the applicant. That's off-record communication outside the hearing. You don't want to do that. That will taint and provide some grounds for, I guess, bending the decision for an appeal. So definitely avoid that. You want to appear as sort of an impartial and fair decision maker when you address these items. And that's why disclosures such as at the beginning here are important as well. So, okay, and I think that's it. And thank you, Ms. Bry, for identifying the 2019 training.
Yeah, there's actually one other thing that there's a wrinkle in the code when we're having a quasi judicial hearing on an alcohol license. The code actually provides you the opportunity for ex parte communication. So you will find that in the code. Someday you'll say, this wasn't true what I heard. No, it is true. What it is in the case of the alcohol license in particular, we are not the granting agency of the license. It's the state, it's AMCO who is the actual grantor. So my predecessor, two people before me, put in a caveat that said assembly members can in fact talk to petitioners for a license, but that gets really complex because also we have the special land use permit, right? And so are you just talking about the license or are you talking about the license and anyhow? So that gets really complex. And in particular with marijuana licenses, we are a licensing authority. And so it's very important in that context to maintain the boundaries around the hearing process that we're having. And if just to put it into a real world context, the assembly on behalf of a request that I made protested a liquor license and AMCO accepted the protest and denied the license. And this was going now 2 years almost ago. And we have been through an administrative hearing. We've been through appeals to AMCO twice. We are now going through the Superior Court, and I will probably be off this body before it goes to the Supreme Court to be decided. And an action I could have taken in the past relating to what that hearing, if I had stepped out of the bounds, could have caused a grounds for an appeal to be heard and the denial to be rejected. And so when we're talking about these property rights, it's very, very important to honor this theory of the quasi-judicial role of the assembly in relationship to the authoring of these rights or granting of these rights. So that just puts a cap on it for me. Anyone else? Okay, so let's now dive. Oh, Ms. Brown, you had a question.
Yes, I do. So you're saying quasi judicial for these liquor licenses. Isn't that for all of them, or is this specific to axes and liquor?
No, it's all of them.
Okay,
It's
that's what
anything that fits into that 15 section on the agenda, and occasionally some things in the 12 or other sections, but it's anything in the 15s relating to the granting of liquor licenses, and sometimes also with land use decisions, Title 21 zoning decisions on specific lots, changes, etc. But yes, it's anything that fits in this category where we are in a judicial role.
And we are scrutinizing this differently than other ones because of what, I just don't know the reason that other than axes and.
Well, this one will come to when we open it and discuss the matter with the members who want to talk specifically about this one. So this briefing was on the concept of quasi judicial hearings as a whole. Dean, I didn't mean zoning. I meant the further actions, but go ahead.
Oh, yes. I just tried to mention zoning or rezonings, and although they appear, because there's usually a property owner that wants to rezone the area because they want to develop something that's not permitted in the current zoning, it looks a lot like a Title 21 entitlement. Well, like a quasi judicial type thing, but it's not, because of Alaska Supreme Court case law. It said this is a legislative decision, not an administrative one. So it's we're in a minority of states who talk about it. So I mean, it's one to clarify that part, and that means ex parte restrictions don't apply when it's a rezoning item on the agenda, and you don't see them in the 15s.
Right. There are other parts of the land use code that fall in that. So Karen, I think really to get another element of the main point, when we are acting in our legislative capacity, which is all those other items except for these things that are quasi judicial, the courts will provide great deference to our decision as a legislative body. We are the decision maker. And so what happens is the court will generally defer to our decision as the ground of the conversation, and then hear facts that might change that position. In the case of the quasi judicial hearings, it is based on the record, right? Not on our opinion as a legislative body, 7 members. It's based on the record. And so because it's the rights of the individual or the business. So that's another wrinkle, but we could probably go, Dean, go ahead if you want to correct anything or.
Yeah, thank you. I would just add that this work session is sort of an opportunity for you to ask questions from, I guess, I believe the applicants here or the planning department staff, and, you know, pull out information that you want about frosted acts and this permit that you put into the record. This work session is part of it.
Yep. And so now we can get specific. And before we do that, Ms. Alatel.
Thanks. Just as we're turning to the item of the Frosted Act special land use permit, the applicant came up and talked to us at the end of Tuesday night. Following that, I went and gave him the information about the work session one-on-one, and he had some questions about the intersection of the special land use work session and his license, and I referred him to Francis McLaughlin, and that was the end of my communication with him. But I think it's important, so we just talked about not having ex parte communications, to make that disclosure and put that on the record. Thank you.
And that was at the meeting.
Yeah, it was right after the meeting, after we had adjourned. Thank you.
Perfect. Yeah, thank you. Okay, and Jamie, Ms. Hines.
Thanks. Just also for clarification, I just want to say that when I trained council members, because they were council in city, we talked about your findings have to be based in law. So when you're sitting as in a quasi judicial capacity, you're sort of sitting as a judge and deciding whether or not the application meets the criteria in law. When you're sitting as a legislator, you get what feels right to you. What are your constituents saying? What is right for the community moving forward in this path? When you're sitting in a quasi judicial, you have to make sure that it meets the law, and if the standards are met and the law is satisfied, then you have to grant that license. You can't say, oh, well, somebody came to us and said that they felt like there were too many licenses in this block. That's not something that the law contemplates. They've already contemplated that Anchorage can have so many licenses based on our population. So the law doesn't contemplate where exactly the places can be. And so when you're considering this, you have to really look at the approval criteria. They're separate for special land use permits as they are from liquor licenses and marijuana licenses. But there will be a section in the documents behind the legislation that speak to the criteria, which are the laws and how those standards have been met. So if you're overturning something that says that the standard has been met, you have to follow that up with findings and make those findings on the record.
Right, and so
that capped that off.
Yeah, it's helpful there. Never underestimate the power of a legislative body sitting in a quasi judicial role, though, to find if there is a reason under the law. And so don't think that you are bound simply because a staff report says something, that is the facts. because a staff report is a staff report. It is the assembly's job to make the findings. If the finding is, no, the staff report was wrong, that's okay. It just has to be based on meaningful, not arbitrary, not capricious, and not unreasonable matters. And Dean, I'll give you the last word on this before we have to dive into the specific matter.
Yes. Is that for me?
Well, yeah, I see you in the queue.
Oh, thank you. Yes, and of course, just want to expound a little on two things. Recently, one was Ms. Hines is absolutely correct, and the law applicable here, especially the frosted acts, the only time you get special land use permits coming up is always referenced in the documents. And here on page 1, line 21, we see the reference to Municipal Code 1050, AMC 210340, which is special land use permits for alcohol, and AMC 210380D. I mean, you can look up those criteria in law for yourself. You'll see them referenced often in, for your example, here are the part of the staff report from Mr. McLaughlin. He goes through each criteria. And again, as Mr. Constant said, maybe there's other information added to the record in the work session today or otherwise that you might disagree with something here, but you need to have grounds for what you disagree with. Maybe some evidence you might add from the testimony you've gotten on record and things like that. And then I would also just add from what Ms. Zalatel mentioned about ex parte. And, you know, in a small community, especially and often here and Anchorage, we might see something put on an agenda, and then you as assembly members getting calls from the applicant or owner trying to talk to you, and you know the best thing to do is say I can't talk to you about it off record, so but it happens. Maybe they're an old friend, I don't know, whatever the situation is. But the cure for any ex parte communication is disclosure on the record of whatever it was. And that's exactly what Ms. Zalatel did, so that's a great example. And the cure for ex parte communications can be important.
Yep. Okay. And on that note, let's now pivot back to the specific matter before us, AR 2023-365 Frosted Axe Special Land Use Permit. Now, the applicant was probably pretty baffled the other day. Why did this not get approved? Why am I having to come before the assembly? And I don't know the conversation that was had with the applicant by Ms. Zalatel, but I will start by saying I can assure you this is the very first time a liquor license has been proposed in a facility where axes are being thrown. And so that alone was enough to raise interest and curiosity beyond a simple approval, where we wouldn't just, you know, say yes. We have to ask. And so that for me is why one reason why I was supportive of holding this item and having this work session. And so other members will have their own reasons. But I see two people now with their hands up, Mr. Myers and Mr. Cross, if you can just put in the chat that you want in the queue, it's easier than the hand raised. But first, Mr. Myers and then Mr. Cross.
I think I probably have the same question that Mr. Cross does, Chris. And I guess now that you rephrased it, it makes a little more sense to me. But we have axe throwing in Eagle River, but I guess it's just because they had the liquor license prior to. It's at the Eagle River Ale House from Matanuska Brewery now. And they have a liquor license.
Yeah, that's a good point. That's a different issue, right? So they had a liquor license and they added a feature we probably never even heard about. This is the opposite of that. It's an axe throwing business that's asking for a liquor license. So it's good to know there is precedent. Mr. Cross.
No, that was the exactly point that I was going to make, is that it's just important to me that we treat businesses fairly. And if we have a place that's serving, and my understanding is the applicant is just looking for a beer and wine license. Meanwhile, we have a business that has a full liquor license doing axe throwing, serving hard alcohol, and et cetera. So I'm just making sure we're applying our standards fairly. Thank you.
Yeah, and I don't think anyone's suggesting not approving this at this time. So just everybody be clear about that. Mr. Johnson.
Yeah, thank you. And I appreciate the briefing from legal on the best way to handle these. And just as a matter of record, I will say that I did go to Frost Axe a couple weeks ago and had a conversation with the owner there about their operations and the fact that they were applying for a liquor license. So I just want to set the record straight that there was a conversation between the two of us when I was there as a customer, incidentally.
All right. Thank you. Next in the queue is Ms. Zalatel.
Thank you. Yeah, I kind of want to back up. I think there's a little bit of difference between someone who already has a special land use permit, um, who who already has a special land use permit for alcohol, adding an activity such as axe throwing. Like, one, I had no idea that was occurring, versus one that is having the activity asking to add a beer and wine license and has to get the special land use permit, right? It really goes back to, we're going to evaluate this based on what's before us. And so I was in a position like Mr. Constant, like, to see this, like, come up. I want to get the facts. I want to understand the record, because granting the special land use permit is us giving our local authority, our local approval, for the service of beer and wine while engaged in this activity. So I think, this isn't meant to single out any applicant or anything like that. However, I can't know everything that's happening in the community at all times. And I am not a regular axe thrower. And so for me, this work session is really great because I'm going to learn more about the activity that, piqued my interest about this, so that I can do my job, which is ensure that if we do these things, that there's a good safety plan in place. And it looked like from an email that was forwarded from, I believe, Miss Honest, the safety plan has been vetted by AMCO, and that's really good. And that was good to know. And that presentation had happened, but we didn't know that even at the time that we postponed this item, because that information hadn't been shared. So thank you.
All right, Ms. Brawley. You're muted. There you go.
Sorry.
You're muted again.
Oh,
there you go.
Yeah, sorry. It was a delay. I had a specific question, and I'm trying to get back to the item, but I wondered if there's a premises diagram in there, because I was just curious exactly. And I'm thinking of a situation like a bar that has darts, where often there's sorry, not the site, it would be the interior. Hopefully there's some kind of premises diagram in there. So I'm just wondering, like, basically what